Hello, my name is John Davis and I'm head of the technical department at ACCA. I'm going to talk about the changes in the regulation of money laundering that are going to impact on all accountants who work in public practice and in the financial services sector in the near future. All who work in those two sectors should by now be very familiar with the obligations they have to watch out for signs of money laundering in the affairs of their clients and to take appropriate action if and when they come across them. The obligations that accountants the world over now have in this area are in all cases imposed by national law, but are invariably based on the high-level recommendations, which are now officially referred to as standards, that are issued by the Financial Action Task Force, or FATF as it's called for short. FATF is the global agency whose remit it is to gather intelligence on how money laundering happens and to put in place a globally joined-up solution to what has become a major area of international financial crime. The standards developed by FATF are aimed not only at accountants but at a wide range of financial institutions and professional advisors who together I'll refer to in this talk as regulated persons. The purpose of this short film is to provide a brief update for accountants on the changes that have recently been made in the standards issued by FATF. The virtue of talking about the changes now is that the revised standards stand to be transposed in the near future into all the legal and regulatory frameworks that regulated persons have to comply with in their various jurisdictions. And some of the changes that are going to happen are likely to have a particularly big impact on the work of practicing accountants. Before looking at those changes in detail, I'll start off with a quick reminder of what money laundering is all about and what must be present for an act of money laundering to attract the attention of people like accountants. The most commonly quoted definition of money laundering is the one you see posted here. Money laundering is the process whereby criminals attempt to disguise the true origin and ownership of the proceeds of their criminal operations. In other words, the process of laundering money has the aim of taking the proceeds of criminal activity and removing all traces of their association with crime. The ultimate objectives of that action being, firstly, to ensure that the perpetrators and their accomplices cannot be brought to justice, and secondly, to allow them to use the proceeds for their own purposes. Depending on the amounts of money involved, the steps that they need to take to achieve these objectives may be as simple as physically transporting cash across borders to extremely complicated schemes that involve the passing of funds electronically through many institutions in many countries. For legal purposes, the FATF standards rule that two key elements must be present for any act of dealing with the proceeds of crime to stand up as an act of money laundering. The first element is that the act of dealing must incorporate conscious behaviour on the part of the person who is doing the dealing. If it happens accidentally, for example, then it's not technically caught by the definition, so it cannot be treated as an actual incident of money laundering. So if a client breaks the law by accident and benefits financially from doing so, then that act would not by itself fall to be treated as an act of money laundering. The second element is that an act of money laundering requires there to be knowledge on the part of the person who is dealing with the funds that they represent the proceeds of crime. So again, if a person genuinely does not know that money or other assets are the proceeds of criminal activity, that person cannot commit an act of money laundering when he or she deals with the assets concerned. Taking those two key points together, an act of money laundering takes place when a person commits an act of dealing with the proceeds of criminal activity and does this intentionally and with knowledge that the property concerned amounts to the proceeds of crime. Those 2 points are central to the understanding of money laundering activity, and they remain unaffected by the changes to the FATF standards that have occurred recently. Before going on to look at the new changes, first of all, a quick summary of what does not change in the revised FATF standards. In fact, the basic requirements don't change very much at all. FATF still calls on practicing accountants and all regulated persons to conduct due diligence on new clients so that you know exactly who you're dealing with and what the new client is asking you to do for them. You must keep records of the information you obtain in pursuit of the due diligence requirement for at least 5 years from the end of each business relationship. Firms should adopt in-house policies and procedures to help them ensure they are not being used for money laundering purposes. These programs should include internal controls, an ongoing employee training program, and an audit function to ensure that whatever policies and controls you introduce are actually working. Most importantly, whenever you as a regulated person know or have reasonable grounds for suspecting that funds are the proceeds of criminal activity, you should be subject to a legal obligation in your country to report what you know to the relevant authorities so that they can decide whether to investigate, to bring prosecutions, and to take action to recover the funds concerned. Most practicing accountants across the world will already be required to comply with the requirements on all these matters. Of the things that have changed in the revised FATF standards, the first to mention, and this is one which is likely to have a significant effect on practicing accountants the world over, concerns the range of originating offences or predicate offences, as they're technically called, that each country is encouraged by FATF to regulate within its national anti-money laundering framework. Not all types of crime are required by FATF to be regulated in this way, which is why the list of predicate offences published by it is so important to the understanding of accountants' responsibilities. The full list of those offences can be seen in the slide here. FATF calls on all countries to ensure that criminal offences in all the categories you see here should be classed as money laundering activities when they give rise to proceeds, and those proceeds are subsequently dealt with intentionally and with conscious knowledge, as I explained a moment ago. The important change to note is that, for the first time, taxation offences are brought into this list of predicate offences. What this means is that all countries are now expected to ensure that where an individual or corporate taxpayer commits tax evasion or some other serious tax offence, the taxpayer is able to be prosecuted on a charge of money laundering. What it also means is that people like accountants, when they have either knowledge or suspicion of the offence committed by the taxpayer, will have their own obligation to communicate what they know to the authorities in the country concerned via their obligation to report suspicious transactions. In some countries, such as the UK, this particular change to the FATF standards won't actually make any difference in practice at all, since UK law already deems tax offences to be predicate offences for the purposes of its national anti-money laundering framework. But for those many countries where tax offences are still not considered to be money laundering matters, the law will have to be changed to reflect the revised FATF recommendation. And this process is likely to impact substantially on practicing accountants in the years to come, given that tax advice forms such a key element of the service provided to clients by many practicing accountants. And the result is likely to be that accountants in some countries will feel the impact of anti-money laundering legislation for the first time. The revised standards place new emphasis on the importance of all regulated persons assessing the specific risks of money laundering that they face in their particular business circumstances, and then taking those risks into account in planning the way that they carry out their anti-money laundering responsibilities. The rationale for this new stress on risk management is to get each regulated firm and person to think carefully about how they do business and where they do business, what sort of client base they have, and what their business model means for their exposure to the risk of being used by criminals for the purposes of money laundering. So individual firms are required under the new standards to carry out their own risk assessments, and on the basis of that assessment to take effective action to mitigate the risks that they face. This is a conscious attempt to get firms to take a proactive approach to dealing with these issues and to encourage them to think actively about their possible exposure to money laundering risks in order to try and preempt them as far as they can. In part, it's also an acknowledgement that combating money laundering effectively is not something that can be done on a one-size-fits-all basis. Control measures are likely to prove most successful if they're thought out and applied in a way which is commensurate with the actual risks that businesses of different types and sizes face in the real world. Different sizes of firm and firms with different types of client may have different levels of exposure to money laundering risks, and these should be identified and preemptively addressed on a firm-by-firm basis. The third important change I'll mention in this brief talk concerns politically exposed persons, or PEPs as they're known for short. Under the existing recommendations, FATF says that regulated persons must carry out what is called enhanced due diligence when they are considering entering into a business relationship with someone who fits the description of a politically exposed person. In other words, someone who has been entrusted with senior public functions, whether in politics, the judiciary, or the military, in another country. The enhanced due diligence called for in these circumstances is designed to ensure that more extensive checks are carried out into the identity and motives of a client who perhaps has the means to divert public funds out of his country. Those existing obligations remain in the revised recommendations, but there are two important changes that national governments will have to incorporate into national law. The first change is that regulated persons should be expected to carry out these enhanced checks not only in respect of new individual clients, but also in respect of the so-called beneficial owners of companies and other legal entities, meaning individuals who have a controlling ownership stake in an entity. So, for example, if you, as an accountant, are asked in future to enter into a business relationship with a company, and you find that the controlling shareholder in that company is a politically exposed person, then you would be expected to carry out the enhanced checks into that person, just as you would if that person was a prospective individual client. The other important change in this particular area is that the definition of politically exposed person is effectively extended to cover not only those from abroad, but also those from your own country. So in future, the idea is that accountants will be expected to take what the standards call reasonable measures to determine whether a prospective client or a beneficial owner of a prospective corporate client is a domestic PEP. Thereafter, the steps that you'll be required to take under the new standards will depend very much on the risk profile of the person concerned. Where you consider the domestic PEP to present a high level of risk, then you will be required to apply the same enhanced due diligence measures that you're currently expected to apply to foreign politically exposed persons. Where the domestic PEP is considered to be a low risk, then you'll just be called upon to carry out the normal due diligence checks that the standards expect you to apply with any new client. So there will be a measure of discretion allowed to regulated persons to determine the appropriate level of diligence to carry out in respect of domestic PEPs. So where we are right now is that the international standards, as issued by the Financial Action Task Force, have been updated, and the onus is now with national governments and regulatory bodies all over the world to take the necessary action to bring their anti-money laundering frameworks into line with the revised FATF standards. In Europe, the European Union is already at an advanced stage of changing the law that applies to regulated persons there. Its draft legislation, in the form of the fourth European Directive on money laundering, incorporates reforms on all the matters that have been amended in the FATF standards, including the three specific matters I've just covered. The new directive will, in due course, need to be transposed into national law in all the 27 member states of the European Union, and that will be happening in the near future. In the UK, the official supplementary guidance for accountants that has been produced by the professional bodies here and which is available on the ACCA website is being revised to take account of the forthcoming changes to the law, and the revised guidance will be available as soon as the legal changes are brought into effect. So, to conclude, all accountants who work in public practice and the financial services sector need to be aware that their obligations in respect of money laundering are about to change. All national governments are currently expected to take the necessary steps to incorporate the revised FATF standards into their national frameworks. Accountants should be especially aware of the new emphasis on risk management in the revised FATF standards. So it would be sensible for all firms to preempt the forthcoming changes in the law by giving some attention now to their risk profile and to what additional measures they might consider taking to reduce their exposure to risk. Thank you very much for watching. The final slide here contains some links to further information that I hope will prove helpful.